Hello, good afternoon, and welcome to King's Court of Protection Team's panel discussion this afternoon on the issue of capacity. And we're particularly looking at striking and discussing the striking of the right balance between what the court needs for capacity evidence and the requirements of the independent expert, or indeed any expert. So to discuss these issues this afternoon, I welcome my esteemed external panelists first. If I could introduce Mr. Justice Poole, who is a High Court judge of the Family Division and sits as a nominated judge of the Court of Protection. And since his appointment in October last year, he's resided on quite a few complicated and complex issues in the Court of Protection and the Family Division. In his previous experience as a barrister, he practiced in clinical negligence and healthcare law, and in fact was a head of chambers here at King's from 2017. Our second panelist is Dr. Lisa Rippon, a consultant psychiatrist for children and young people with learning disabilities and development disabilities. She's a prolific independent expert in the Court of Protection. That's the way I kind of describe her. I think I've seen reports from her since the first day I was practicing in the Court of Protection. She also sits as a medical director for specialist services for children and young people, and is a named doctor for safeguarding children at Northumberland, Tyre and Weir NHS Foundation Trust. I also welcome Aisling Campbell and Sophie Hurst, two outstanding juniors here in the Court of Protection team, who will be taking us through practice and procedure after our Q&A session with our two panelists. So, without further ado, if I could come to you first, Sir Nigel. It's been over 6 months, I think, since your appointment to the High Court, and you've been involved in, as I said, an array of quite significant Court of Protection decisions, including AMDC, which we're going to talk about in some detail later, but also Pippa Knight in the Family Division. How have you found, if I may, the transition between practice and adjudicating on such complex decisions?
Seamless, Sam. First of all, can I just say it's wonderful to be back in King's Chambers, if only remotely. But I left it remotely during the lockdown, so nothing's changed in that sense. One of the oddities, actually, of starting sitting has been to do it during the pandemic. So most of my hearings, all but 2 or 3, have been conducted remotely. Obviously, changing from a clinical negligence practice at the bar to sitting in the Family Division makes for a steep learning curve. But with the Court of Protection work, there are some similarities between that and clinical negligence. There are some overlaps. There are concepts such as capacity that are familiar to me through practice at the bar that translate a little anyway into the Court of Protection work. And I have found the Court of Protection work particularly interesting and something I wish I'd done more of at the bar, but that is to lead to the confession that, of course, I do have limited experience from the bar of the Court of Protection, and so all of my learning has been, as it were, on the job as a judge at the Court of Protection.
Thank you. AMDC was a case which I think you decided pretty early on after your appointment. And you emphasized in the judgment a certain paragraph from Baker J, as he then was, in Cheshire West, about the Court of Protection being inquisitorial rather than adversarial proceedings, in the context, I think, of further evidence that was required for capacity in that case. How important do you think the inquisitorial nature is in the Court of Protection, especially coming from it from other jurisdictions?
Well, I was used at the bar as a clinical negligence practitioner to, the familiar sort of civil process of claimant brings allegation, claimant has to prove allegation, defendant doesn't have to prove anything. If the evidence doesn't come up to muster, end of case. And we'd sort of reached that position in a sense in the AMDC case in AG that you mentioned, because the local authority relied upon an expert who, after he'd given his evidence and being cross-examined, it became quite clear that they came to the court and said, we can't rely upon that anymore. But there's no question within the Court of Protection of saying, well, that's the end of the case. The court takes the lead, if you like, in the Court of Protection. It is, as Mr. Justice Baker, now Lord Justice Baker, said, it's an inquisitorial process. And so you can't simply dismiss a case of that kind simply because the evidence hasn't, as I put it, come up to muster. It was really a case of saying that further evidence was required and the court taking some control over that rather than just dismissing the case. This wasn't a case where it could say, I've had satisfactory evidence and it doesn't establish lack of capacity. It was the evidence was sufficiently unsatisfactory that one couldn't determine it either way. And so that's why the court had to take a lead on it and allow for the instruction of a further expert.
And one part of the judgment dealt with, I think, paragraph 4.16 of the Code of Practice, which deals with the importance of providing P with the relevant information before an expert completes the assessment. But I mean, just moving away from that slightly. But I mean, how important do you think? I move away from the actual facts of that case. But how important do you think it is for when you are when the court is determining these issues for the expert to actually provide sufficient evidence in the report that they've provided that relevant information and then it's well documented in the report?
Well, I was asked to and set out some ideas in terms of guidance for the preparation of reports. And the focus of them really was this, that the assessment by an expert is one thing, the report to the court on capacity is another. And so the focus of the guidance that I gave was to try to ensure that the reports that are prepared assist the court. So you could sum it up in one phrase, which is experts should show their workings. So it's one thing to do the assessment, but the court wants full explanation or adequate explanation as to how the assessment, how the conclusions have been reached. So that would include, for example, setting out what were the relevant facts, what was the relevant information that was discussed with P, what steps were taken to support P, in particular in that case, there'd been, I think, 3 face-to-face interviews between the expert and P, who's a woman with dementia. And there was an issue about fluctuating capacity, but if I may say so, one of what was fluctuating was her level of engagement. And by the 3rd interview, she was royally fed up with being asked questions, in particular about her sex life. And so the expert hit a bit of a brick wall. But what the court needed to know was what steps had been taken to try and overcome that and to allow her to engage and support her to engage. So a statement from the expert that P wouldn't engage is insufficient. I didn't know as a judge what steps had been taken by the expert. And that's the sort of thing that needs to be spelt out in the report. So the report is very much for the benefit of the court, and the parties will direct the expert through the letter of instruction in particular to those issues that the court needs assistance with. It's not just a general clinical assessment. It's targeted to assist the court. And so experts not only have to do their assessment, but they have to be proficient in writing down in a report form, or the report in a form that is going to assist the court. And as I say, I suppose the advice boils down really to show your workings.
Sure. And so when it comes to the report itself and for the purposes of assisting the court, would you say that if there have been differing conclusions in respect of someone's capacity, for instance, as you mentioned, fluctuating, or other such decisions. Do you think it's important for the reports to clearly reconcile the differences that were reached clearly by the expert?
Yeah. So is an example from that case that I think after the second interview, I think it was the second, the expert had concluded that that P had capacity in relation to sexual relations, to engage in sexual relations. The expert was then sent a letter or statement from allocated social worker, I think, and wrote another report without seeing P again, giving a different conclusion. And I'm not saying that would never be permissible by any means, but what the court needs is a full explanation of a significant change of that kind. It's not sufficient just to say, I've received this evidence. Considering all the evidence, I now conclude X, Y, Z. I suppose an expert has to recognize when there's been a significant change in their conclusions, they need to set out and explain to the court why they've changed their conclusions. I suppose that's obvious, but it didn't happen in that case. I dare say there are other cases where it hasn't happened also.
Sure. I mean, when you use the word obvious, one of the other, I suppose, obvious principles in the Mental Capacity Act is under Section 1.3, which is that you must support individuals as far as possible in making a capacitous decision. Do you think it's important then for experts to set out in the report what support actually has been provided to P and to what extent?
Well, if they don't, they're liable to be asked about it anyway, of court, if the case reaches court, and it's more likely to go to court and for them to be called to give evidence if they don't. So, yes. So fundamental that it does, I think, behove an expert to explain in their report what steps they took to support P, for example, to engage in the process of assessment and indeed to make decisions. There's a case of Mrs. Justice King called Re DE 2013, High Court 2562, where she sets out in great detail steps that had been taken, or we shouldn't set it out in great detail, but you can see the detailed steps that have been taken over quite a length of time to support P in relation to, I think that was engagement in sexual relations, with a series of meetings or time spent with P to discuss various aspects of that decision making. And it just shows you the lengths that can be gone to support P to have capacity in relation to a certain area of decision making. So it is the sort of thing that the court is very anxious to know about and ought to be set out in the body of the report. I mean, I do take into account that the court doesn't want to overburden, first of all, lawyers in writing, 25, 30-page letters of instruction, and not to overburden experts. But nonetheless, these are pretty fundamental points that need to be addressed on the face of any report. And of course, we're talking about experts giving evidence here. If an expert's been involved in the case at all, then usually it would be because is likely to be or liable to be some contentious issue about capacity. So the expert should be on their mettle, as it were, from the beginning, that they'll need to, as I say, show their workings.
Yeah. So in terms of showing those workings, do you think it's important, where relevant, that the expert sets out almost a transcript of the interview or the examination that they've had with P to assist?
No, I don't. I think you have to strike a balance, and the court I wouldn't be thanked for insisting on the courts being given 100-page reports. In certain cases, an expert may wish to append, for example, a transcript or a verbatim note of their interview. There's nothing wrong with that. But in the body of the report, I would suggest that where a particular exchange between the expert and P is of particular importance, they can either give a verbatim account of that exchange if they have it, or at least describe it in sufficient detail that the court knows what happened. It's not really sufficient to say, I discussed contraception, and from P's answers, it struck me there was no understanding, or something of that kind. The court would want to see, know what the exchange was. That's not the same as insisting on a verbatim account, because I think that would overburden the process.
And so in terms of the letter of instruction, which is obviously a fundamental piece of work for the expert to look at, do you think there's any merit in what happens in the family division, which is that I believe the judge approves the letter of instruction before it goes to the expert? Do you think that's something that would work in the Court of Protection, or is needed?
Instinctive reaction is no, because that's more work for already busy judiciary. No, I don't think it is necessary. I mean, where there's joint instructions, of course, the court would rely upon the parties to agree on agree the terms of a letter of instruction. And what's important about it, I bring some experience from clinical negligence in this, and I say this with all due respect to Dr. Rippon, who I'm sure wouldn't fall into this category, but some experts do have a loose hold on what we as lawyers regard as rather fundamental principles. So in clinical negligence, for example, proving some causation on the balance of probabilities. But I would read reports from very experienced experts and experienced clinicians that would say, it's in my opinion, on the balance of probabilities, the delay in delivery may have caused the child neurological injury. And you think, well, the may for a lawyer isn't really the same as balance of probabilities, and it leaves some doubt there. So I think a letter of instruction should lay on a plate for the expert some of the fundamental principles, a reminder to look at the diagnostic element, the functional element, the causal link between them, and to helpfully set out what the relevant information, for example, may be in relation to the decisions that have been asked. There's some guidance from the British Psychological Society, I think it is, some guidance to experts, and they set out, the issues that an expert ought to know they're being asked to address before they give their report, and it applies very widely. But a letter of instruction should address all of those issues. So to remind the expert of the fundamental principles, set out very clearly what the issues are they're being asked to advise on, the decisions that are under consideration, the relevant information. So those are sort of basics of any letter of instruction. I wouldn't ask that the court has to approve that. The risk of sucking up to you, Sam, my experience is that the Court of Protection lawyers are of a very high standard, and the court, I'm sure, would trust them to prepare a proper letter of instruction. I should hasten to add, in the case that I had, there was no criticism at all of the letter of instruction.
Of course, thank you. And finally, just in relation to expert reports and their evidence, we are aware that there's a working party report in relation to family law cases in respect of experts, I think prepared by Mr. Justice Williams. Do you think there are any parallel learning points that can be derived from the conclusions of that report into the Court of Protection?
Well, it was a working group on medical experts, as you say. Mr. Justice Williams chaired it, and their report came out in October last year. One of the reasons for it was the noted shortage of experts willing to give evidence to the court in the family division. But amongst the main areas of shortage were child and family psychiatrists and psychologists. The main issues of concern to them were, the working group surveyed experts in those fields, were remuneration, it wasn't necessarily or solely the level of remuneration. It was the whole process of getting paid was tiresome for the experts. Court processes, including court timetabling, the volume of material given to experts to consider, a lack of support and training, and perceived criticism from lawyers and the judiciary and the media. Though those were the main sort of obstacles, if you like, to experts giving evidence. And so various recommendations were made. I won't go through all of them, but so far as legal professionals are concerned, they might bear in mind, because I do think there are lessons to be learned for the Court of Protection as well as the Family Division, were ensuring that legal professionals adhere to the provisions of, as would be applicable, Part 15 of the Court of Protection rules. A unified point of contact for the expert, so the expert isn't having to deal with different people at different times, if that can be achieved. Making sure that the expert is only provided with the paperwork that they really need, and not just everything thrown at the expert for them to sort out. This comes back to my idea of laying things on a plate for the expert. And treating experts appropriately is the way I think it was put at court hearings. Certainly in clinical negligence, I noticed while I was at the bar a tendency of the court sometimes to kick the shins, if I can put it that way, of an expert who's on the losing side. There's some, tendency perhaps to do that. I've not noticed that particularly in the Family Division or the Court of Protection, but it's something to be mindful of. And greater use of video technology, which of course we've had to use during the lockdown, but I think is something that is here to stay, and happy to talk about that later if you wish. But I know the Family Division and the Court of Protection are interested in views as to the continuing use of video technology, including for the purpose of experts giving evidence at hearings.
Yeah, thank you. I mean, I think that's something, if I could just touch on now, because I mean, in terms of your experience and as far as you can predict, do you believe that the use of remote hearings in certain cases, for instance, for taking expert evidence, would endure when the restrictions ease and in fact the quality of the evidence perhaps has improved? I mean,
well, there is one view that, and I've heard Mr. Justice Hayden, the Vice President, express this view at a seminar. One view is that his view is that the quality of expert evidence, if anything, has been better by being given remotely. Something about the process of coming to court, perhaps it's the theatre of court, he thinks takes away from, I don't know, my words, not his, but the authenticity of the evidence that was given, or that there might be a tendency perhaps to respond to the theatre of the court. Whereas if an expert in their own place is giving, sometimes from hospital actually, is giving evidence by a link, somehow it removes that element. And so he believes he gets a better quality of evidence from experts, and he's much more experienced of before and after in that sense than me, but he thinks he gets a better quality of evidence by experts giving evidence remotely. Of course, on a practical level, it's far more convenient. So experts may come from all around the country, not want to have to travel and perhaps take a full day out to give their evidence, and it's no small matter. It's important, and if the quality of the evidence can be good or even better than they're attending, then that is something that I think we have to look very carefully at in the future. Of course, technology is not always reliable, but that's something I'm sure that can be improved as time goes on. Another aspect, if I may, because I'm not asking for a free-for-all on this, but if anyone wants to contact you and you could pass it on to me, but the idea in the Court of Protection of observers. So observers, I find a number of observers in nearly every Court of Protection case that I have conducted. And will be getting used to being able to access hearings quite easily. How is that going to continue if we return to in-person hearings? That it's not as easy to travel, for example, to the Royal Courts of Justice and find the courtroom and sit in, as opposed to just clicking on a link in the computer. I think it's important to have openness and for observers to be able to observe. So I think that's an interesting area to look at, is to how do we continue with that level of openness that ironically has been more available during the lockdown for when we return to in-person hearings more often. Anyway, that's a side issue, but one that's...
No, that's an extremely good point. I mean, an allied point is actually P's participation in the hearing, because there has been, certainly in my experience, P has been able to participate in cases more so than it ever would have been in physical hearings, just because of location and actual the point of getting to court, and some people not being able to do that.
Yes, indeed.
Well, Sir Nigel, thank you so much for agreeing to be a panelist today. I'm going to move on to Dr. Rippon now, but if you'd stay on the line, as it were, that would be great. In terms of the audience out there, if you have any questions for Sir Nigel, then please put them in the Q&A box at the bottom right of the screen, and we'll try to filter out as many as we can do at the end of the seminar. But thank you again. So, Dr. Rippon, if I can come to you. So we've had a tour de force of what an expert should be doing, and having seen many of your reports through the decade, I think your reports are very detailed and provide, if I may say so, the right balance between in the information and not too much information. But in terms of where we are now in COVID and the prospects of restrictions easing, but over the last year, had you ever envisaged a time when you would be doing so many assessments virtually?
No, it was a completely new experience for me, and a steep learning curve, actually. And when the restrictions first came into play, I didn't think that I'd be doing any assessments until face-to-face meetings were allowed. But quite quickly, I think that it was appreciated that things just couldn't stop, and we had to find other mechanisms to be able to provide assessments for individuals on some very, very obviously important matters in their lives. And so, yeah, the remote assessment started, and it was a steep learning curve as to which individuals could cope with that kind of assessments, what differences, how I had to approach assessments, how that changed. So, yes, unusual experience, but a lot of learning and a lot of positives, I think, that have come out of it.
Yeah. I mean, did you ever, pre-COVID, did you ever undertake remote assessments as part of any capacity assessment? Was it ever on the table as an option?
It was never an option, and I hadn't ever really considered it. And I come from the Northeast, and so I have to see individuals from all over England and Wales, and I didn't even consider it a possibility. I always travel to see people. I think that following my experience, I think things will change, and there will be some people whom I will continue to see remotely, because I think that it does have its advantages. But I've learned with my experiences that there's some individuals that you have to meet face to face in order to undertake a thorough assessment of the areas that you've been asked to assess.
Yeah. Well, I mean, if I can touch on that, if I may. So in terms of remote assessments, and in the future, if they become an option available to all experts, do you think that there are some cases where a remote assessment is simply not acceptable in your part, for in terms of a person's diagnosis? And could you give some examples of where in the last, say, 12 months, you've had those cases and the types of cases you've said, no, I can't do this remotely?
Certainly for individuals who have a more significant learning disability, where I felt that being in the same room with them, having that connection, being able to, make sure that they're engaged in the assessment, that their level of concentration isn't being impaired, that they can understand what I'm saying. I feel for that group of people that it's a remote assessment just is not appropriate. I also think that there's a group of individuals who struggle to engage on a day-to-day basis. And this may be, for example, I've had experience of trying to assess individuals with a more milder learning disability, but who have personality difficulties, who struggle to engage with professionals generally. And what I've found is that their engagement in the assessment process just hasn't been as good as I would normally expect from a face-to-face assessment. You just don't get that personal connection. You don't get to, put the person at their ease, just engage them in an environment that they're comfortable in. The remote assessment seems to put up a barrier to helping them engage. I also have found that discussing some perhaps more personal issues, some sensitive issues, is much more difficult remotely. So perhaps if a person's had experience of abuse, if you're talking about sexual issues, that's much trickier to do remotely than being in the same space as them and being able to take, I suppose that a lot of communication is non-verbal, and that's much more difficult to pick up virtually than being in the same room.
Yeah, I mean, and that's one thing that's been a consistent theme, I think, for all of us, that in terms of the picking up on the social expressions and the nuances of what a person that you may pick up in person, you may not be able to pick up in a remote assessment. Have you found that in particular in a lot of assessments?
Definitely. And I suppose my style of doing assessments is very much conversational and trying to engage a person and trying to develop a relationship, even within, quite a short period of time. And you do the assessment by picking up on those cues. You pick up on cues that the person's engaged, that they're listening to you, that they're understanding you. And that's so much more difficult to do remotely than if you're in the same room as somebody.
Yeah. And do you find that before you actually conduct an assessment, there is a need to do a lot of preparatory work in terms of setting P in the right state of mind, for instance, or putting them at ease, or liaising with support workers and those instructing you to do a lot of work before you start the assessment?
Yes, so your starting point is your letter of instruction, and I completely agree. A good letter of instruction is so helpful when you're thinking about preparation for an assessment. So from that, you can glean some information about the individual and what might be the barriers to engagement. So what I've done is that I have spoken to carers before, meeting P, but be that remotely or face to face. I've spoken to social workers, sometimes community nurses, just to try and come to a judgment about what I needed to do to facilitate that assessment. And for remote assessments, what I've also been doing is if I've had any concerns that the individual just won't be able to cope with a virtual assessment, I've arranged test calls so I can actually meet with them, explain what the process actually is, explain what I'll be doing, and then arrange to do the assessment again so that their level of anxiety is reduced hopefully, and that will improve the quality of the assessment.
Okay, and so, I mean, just following that through, do you think it would assist in a letter of instructions for remote assessments, for there to be some specific consideration about the pre-work that needs to be done and your involvement in that work?
Yes, it would be helpful. If it was known that an individual struggles with communications, that there's some things that you should not say during the interview. There's some tricky areas. That it would be helpful to know that, and it would be helpful to know if it would be necessary for me to speak to a family member or a member of staff or a community nurse to get an understanding of how that individual communicates and how best to facilitate the assessment.
Right. When I was speaking to Sir Nigel a few moments ago, I was talking about, and we spoke about visual prompts and supporting P through the assessment process. How on earth do you do that remotely?
You can't, and I think that again is one of the areas that you need to consider when you come into a decision about whether a virtual assessment is possible. So, for example, I'm doing an assessment in a couple of weeks where I'm having a speech and language therapist is accompanying me to have the visual supports. So that's going to be absolutely crucial for that assessment, and I couldn't have done it remotely. Often during my assessment, particularly for when I'm discussing sex, I'll use some simple pictures to help the individual describe what sex is, etc. That's not possible to do remotely. But what has been possible actually and worked really quite well is the use of an interpreter. So I have had a couple of assessments that have required the use of an interpreter, but not required visual aids, and that's been absolutely fine. And I thought, it was a very, very good assessment in those particular circumstances.
Right. You spoke about the letter of instruction giving you as much information as possible to decipher whether a remote assessment can be achieved. Can you, if you can, give us some generic examples of when you've decided that this simply can't work? I
think that if the individual has struggled to engage with professionals in the past, where they do need a lot of visual supports to facilitate their understanding, for non-verbal individuals who perhaps need to use Makaton. I think certainly for individuals with severe autism, I think they find remote assessments very difficult. Perhaps when level of concentration is a factor. So for people with severe ADHD who would struggle to sit in front of a computer for a couple of hours, if you were doing that face to face, it's much easier to gauge that their concentration is diminishing and they can get up and move around and self-regulate, then come back. So I think those are key features. And when it's known that perhaps an individual suffered significant abusive experiences, and you may need to discuss those during the assessment, I think that's very difficult to do remotely, and I would prefer face-to-face assessments in those cases.
Okay, that's useful to know. Thank you. We were just touching, obviously, on the letter of instruction. You've seen many letter of instructions, I'm sure, through the years. Can you indicate to us the type of things that you find useful in letter of instructions, and perhaps things that you don't find useful?
I certainly agree that outlining the relevant information and the up-to-date case law is crucial. I suppose because I do a lot of this work, I try to keep up with the relevant case law, but sometimes I miss things. So having that clearly laid out is very important. I think that, most letters of instructions will remind you of what you need to document in terms of the causative nexus, etc. So yeah, I think that's helpful. I think that even though you get sent a lot of the background information, having a brief, just summary of a person's background and how they've ended up in the Court of Protection is helpful. And what I would say is that sometimes I've found letters of instructions quite repetitive. So just try to keep things as streamlined as possible. And so those are the main things. What I would say, just talking about background information, that is helpful. I think what has certainly improved things for me is having digitalized information. So rather than getting 10 lever arch files through the post and having to go through them, having Crypt Share or whatever is incredibly helpful and does help me actually identify what are the key documents that I need to look at.
Sure.
So that is really helpful rather than paper records.
Great, thank you very much. The final thing, Doctor, that I just wanted to touch with you on was a question that was raised when we sent out the invitations, was in relation to fluctuating capacity and in particular emotional dysregulation. Now, it's fluctuating capacity vexes everybody because it's sometimes there's no right answer, especially when it's unpredictable. But for you as an expert, what do you find most difficult to grapple with when it comes to cases where fluctuating capacity is relevant, and in particular when it comes to emotional dysregulation?
In my day-to-day clinical work, emotional dysregulation is such a common feature of the individuals that I work with, and I think it's a difficult area for everybody who supports those groups of individuals, particularly those with, for example, emotional unstable personality disorder, and how to support them when their mental state deteriorates. But in terms of the Court of Protection, I suppose it's how to, for me, it's thinking about what the court actually need to know. I can advise that when this individual's level of anxiety increases, that will have an adverse impact on their decision-making capabilities. And so in those periods of time, I might conclude that they'll lack capacity to make decisions around care, that they'll disengage, that they'll put themselves at risk. And for me, it's I can advise that those individuals can say when they're well that, when I'm in this state, please put all of these safeguards in place for me. Don't let me leave the house. Don't let me do X, Y, and Z. And I suppose this is the crux of the matter, isn't it? It's whether those individuals can almost use an advanced directive approach. Can they say that when I lose capacity, shut the door, lock the door, keep me safe? Or does the court want to go for the longitudinal type of approach? So, and I never know really, it's sometimes difficult for me to make a judgment about what to advise.
Sure.
Yeah. So it's, and I can see that if somebody's emotional dysregulation is several times a day, every day, then the court might want to take a longitudinal approach, but perhaps if it's once a week. I think some case law on these issues might be really helpful.
Yes, and I'm sure there's lots of nodding heads in relation to that. I mean, do you think it? I mean, just final question for you: do you think it would assist that if the parties set out very clearly what their positions were in the letter of instruction in terms of fluctuating capacity, so that you could see how it may potentially fit into a party's case?
That would be extremely helpful, because the last few cases I've had on fluctuating capacity, I've really struggled to provide opinion that I think is going to be helpful for the court.
Yeah.
And these are always invariably the trickiest cases, with individuals who put themselves at such significant risk that it raises huge anxieties.
Yeah. Well, Doctor, thank you again for taking the time out this afternoon to come and join us as a panelist today. It's been really insightful. And if you can stay for the next 10 to 15 minutes, then please do, and we'll see if there's any questions beyond what have already been put. Okay, so I will now hand over to Ashley and Sophie to give us a bit of an outline in terms of the practice and procedure of when capacity is relevant in the timeline of a case.
Thanks, Sam. So the purpose of this section of the talk is we thought we'd take what we've spoken about so far today and the insights we've had from Sir Nigel and Dr. Rippon and try and apply them to the life cycle of a case, in particular looking in a bit more detail at that judgment in AMDC, where Mr. Justice Poole sets out some guidance for experts. And I think he says in the judgment that the guidance is specifically aimed at sort of your Rule 15 experts, but it equally applies to Section 49 assessors, social workers, best interest assessors, and can be used also by people managing cases, solicitors and lawyers like ourselves, who are looking to gain further evidence in relation to capacity in cases.
The typical case we've gone for is a classic Section 21A case that we would all have in mind, I'm sure, where usually the starting point is an assessment done in the DOLS Form 3 or the DOLS Form 4. And our suggestion would be that if you're a solicitor for the local authority or you're acting for the local authority, you consider whether there's been any previous assessments done in perhaps the past year or so, and consider disclosing those nice and early, because it starts to build up a picture of evidence rather than there just being one single assessment before the court. And also to think about whether there are any weaknesses in the assessment that you're relying upon that you might want to preempt. So similarly, at this stage, if you're acting for P, it's probably a good idea to either try and meet with P or do a remote attendance upon P to build your own picture of their engagement and their communication and what you feel their level of understanding is. Particularly because for those people who are borderline on capacity, you might want to get more input from them when you're taking instructions. And then hopefully you'll have a litigation friend or an ALR who can give you some views about whether they think P has capacity or not, because quite often we might see these sorts of assessments where the assessors maybe got to the right conclusion, but as Mr. Justice Poole has set out, hasn't shown the working to get there.
And just to pause on the idea of those DOLS for Form 3 and Form 4 assessments as well, I think one thing that perhaps sometimes we're a bit too keen to do is dismiss them as simply Form 3 or Form 4 assessments and go, right, well, we've got that, but now we need further capacity evidence. And I think, proportionality is sometimes a little bit lost at this stage in Section 21A proceedings, for example, because quite often the best interest assessor is going to have interviewed P, they're going to have interviewed relevant interested people such as family, friends, care staff, and so on. So actually, they may in fact have produced a really thorough assessment which really takes into account those Mental Capacity Act principles. So when you get those first capacity assessments, do look at them, question them as if they were your Section 49 reports, your independent expert reports, because it may in fact be the case that there is enough there. That's not to say, however, that if you do have doubt, you shouldn't go and get further expert evidence. As we all know, in the court of protection, the presumption is that P has capacity. So if the doubt is there, do go and get that further expert evidence. And I suppose the next step, if you like, is to consider, if you do want that further expert evidence, well, what type of evidence do you want? And you've got a number of options. You could go back to the social worker and ask them to produce another report. You could go down the Section 49 report route, or you could get an independent expert. And each of these ways of getting that further capacity evidence has its benefits and burdens. And some of the things that you might want to consider, whether you're acting for P or the local authority, in these cases might be things like the complexity of the case. So if P's diagnosis is going to require specialist input. So, for example, I had a case recently where P had a diagnosis of Prader-Willi syndrome. And right at the start, both parties thought we're going to need someone who has more specialist understanding of this particular diagnosis. So we went straight for the independent expert. Equally, if P has long-standing relationships with the trust, maybe they're under a particular psychiatrist or psychologist, you might want to go down the Section 49 route, because actually the trust could identify someone who is well aware of P's history, and they may be able to produce a much more thorough report than if you went to an independent expert who's only met P the once and is having to, as Dr. Rippon's pointed out, go through all those paper files. That also speaks to timescales. If you've got an independent expert who's going through all that information, for the first time, they may take a lot longer to come back than Section 49 doctor. Although equally at the moment with COVID-19, we all know what pressure trusts are under, and the timescales certainly in my experience seem to be creeping longer and longer and longer as we work through the pandemic. Finally, as well, cost. I suppose it comes down to that as well. Independent experts are going to cost you money, whereas Section 49 doctor perhaps won't. And so these are some of perhaps the things to consider when deciding where you go to get that further capacity evidence.
When you've received the report that you've asked for in whatever form, we think that's where Mr. Justice Poole's guidance in the AG case really becomes the most helpful. At paragraph 26 of his judgment, he said the inquiry into capacity will vary considerably from case to case, and experts must always be sensitive to what is required for the individual assessment in which they are engaged. So once you've chosen the exact expert that you're going for, we think the key message really is that each expert needs to be alive to the fact that an assessment in one case might be quite different from the assessment that they need to undertake when they're looking at a different protected party. Then paragraph 28 of the judgment, it's very odd talking about Mr. Justice Poole as though he isn't here. He sets out 8 considerations for assessors to look at, which we're going to go through in turn. So A and B, first of all. A says an expert report on capacity is not a clinical assessment, but should seek to assist the court to determine certain identified issues. So it should pay close regard to the MCA, Code of Practice, and the Letter of Instruction. And then B goes on to say that the letter of instruction should identify the decisions under consideration, the relevant information for each decision, the need to consider the diagnostic and functional elements of capacity, and the causal relationship between any impairment and the inability to decide. The guidance for experts there really is that they can structure their reports according to those sort of subheadings. But again, we think the key message here is to take care in producing the letter of instruction, which is probably the theme of this part of the seminar, really, because if you want the assessor to consider certain issues or particular circumstances that are specific to P, it's crucial that you highlight that in the background information, ensure that the relevant guidance is there, the case law is updated, and if there's going to come a point down the line where you're going to say, well, how did P respond to this particular part of the relevant information? And you'll expect the assessor to have put that to P to be able to retain, use, weigh, understand. You need to make sure that that letter of instruction sets out what the relevant information is in any particular case. So, for example, the 2 options here are living at the placement or returning to live with mum at home.
C goes on to say that it's important that the parties in the court can see from the expert's report that the expert has understood and applied the presumption of capacity and the other fundamental principles set out in Section 1 of the Mental Capacity Act. In relation to that, I think, as is often the case in letter of instructions, it does no harm to just set out, what those principles are. Independent experts are well versed in them. Lots of Section 49 doctors will be as well, but it doesn't harm, does no harm to just put that little gentle reminder to show experts, this is every time you ask a question, let's go back and just make sure that it does all comply with the Mental Capacity Act and the principles therein. D, it goes on to say, in cases where experts assess capacity in relation to more than one decision, broad brush conclusions are unlikely to be helpful. And also experts should ensure that their opinion in relation to each decision are consistent and coherent. Once again, just drumming the point that the letter of instruction is key here. If you want the assessor to look at specific domains of capacity, set out what those specific questions are and what the specific domains are, and the guidance and the updated case law that is available in each of those specific domains. E then goes on to say, an expert should not only state the expert's opinion, but also explain the basis of each opinion. The court is unlikely to give weight to an opinion unless it knows what evidence it was based on and what reasoning led to it being formed, which is going right back to what we were saying at the beginning of this seminar. It sounds like, I seem to remember this from GCSE maths, is, show your workings out. You get 1 point for the answer, but 10 for how you got there. And it's that kind of thought process that needs to be set out in these reports and assessments of capacity.
Absolutely. So let's assume you've received a report of an assessment, and contrary to everything Sophie's just said, the basis of each opinion isn't set out and you're looking at a lot of broad brush conclusions. In that instance, in all likelihood, you're probably going to want to ask questions of the expert to ask them to reconsider things, or potentially even to reassess P if you really feel that the assessment fell short in its content. Paragraph F within the judgment says that if an expert changes their opinion on capacity following reassessment or otherwise, they ought to provide a full explanation of why their conclusion has changed. So we think this means that you should ask very specific questions and refer the expert back to the points in the letter of instruction that you perhaps feel that they've not quite taken into consideration. So, for example, you might be asking, what was this piece of relevant information that you gave to P, and what weight did P attribute to that relevant information? And you're usually asking these questions because you're testing the expert. You might even want him or her to change their mind about the conclusion they've reached. And it's going to be difficult to rely on that change of opinion unless you facilitate the expert setting out exactly what they've reflected on and how they've come to that different conclusion. At subparagraph G, Mr. Justice Poole talked about the transcription point that we've alluded to earlier. And of course, it's got to be right that there isn't necessarily going to be a full transcribed version of the interview. But we also take from this that it isn't unreasonable to ask an expert exactly what P's response was to a particular question or particular piece of relevant information. We don't think it's good enough that an expert just says, oh, well, P didn't use and weigh the relevant information, without setting out what it was that they did or didn't say about that relevant information.
And the final point in the guidance at H is what we've been speaking about previously as well, which is what happens if the assessor hits that brick wall with P and they stop engaging. And really, the thrust of the guidance here is, firstly, don't just keep mechanically asking P the questions if this could aggravate them, or ultimately it's not going to give you the response and is pretty futile. Instead, an assessor might want to take a step back, speak with care staff, those who know P well, find out if there's any other strategies or ways that might better engage P, maybe even a different time of day, in a different room, in a different environment. And also, and then set out in your report, even if at that point you can't get the engagement from P, what steps have at least been taken to try and help them and promote their ability to engage in that assessment.
So that is a summary of how we think we could apply Mr. Justice Poole's guidance to capacity assessments throughout the life cycle of a case. We hope it's been helpful. I think, Sam, there are some questions in the Q&A and within the chat function that perhaps we've got a bit of time for.
Oh, yeah, I think let's see if we can dwindle them down, bearing in mind the time. I think one question that's been put to Sir Nigel is in relation to the identity of expert evidence and whether there's almost a hierarchy in terms of their specialism. And I think what's meant is that, does the court prefer, for instance, a social worker with considerable experience of P to give evidence, or would it benefit, rather than having that evidence, than having an independent expert?
Well, I think the starting point is Rule 15. So if expert evidence is proposed, the court needs to be persuaded that it's necessary to resolve the issues in the proceedings. And that it cannot otherwise be provided by a Rule 112 representative or in a report under Section 49, as was mentioned earlier. There's no hierarchy as such, but you do need to think about who's the appropriate expert in terms of their field of expertise to meet the particular case. And that sometimes requires a little subtlety of thinking, because there'll be psychiatrists who specialize in different areas. That's not to say that in some cases a psychiatrist who has a more general practice might not be suitable, but in certain particularly difficult cases you might want to get someone who is particularly expert in the field of frontal lobe dementia or whatever it might be. But I don't think I hope the courts wouldn't have a hierarchy in the terms that were suggested in the question. As was rightly said, you need to think about the particular case and who can assist the court the most, which may well vary depending from case to case.
Yeah, of course. Well, I'm feeling a bit generous, so I'll allow two more questions, and this is one for the entire panel, if I may. That it said that obviously, so Nigel, you mentioned the importance, and Sophie and Aisling demonstrated as well the importance of showing your workings before you come to a conclusion. The question is that also relevant for best interest assessments and mental capacity assessments done under the standard authorization process, in particular DOLS Form 3 and 4? Sophie and Aisling, do you want to take that question?
Yeah, I mean, I think the answer is yes. That's one of the reasons why so often we reach the form 3s, look at them and think, well, we need more than this, because, quite often the information's just not there. There is very occasionally as well, sometimes the tendency to sort of look back to last year's Form 3 or last year's Form 4 and sort of base your assessment on that, which, if you've got someone who is suffering from dementia with a prognosis that's poor and they're deteriorating, may, be okay. But I've had a case recently where someone's had alcohol-related dementia, and in fact there's been a regaining of capacity because they've been abstinent from alcohol. And in cases like that just doesn't work, because there is going to be a change. So I'd say absolutely, whenever you're performing a capacity assessment, show you workings of how you got there, or you're either going to be asked about it, or if you are for the local authority, it's going to be necessary for for you to go and get more evidence, or for the court to at least ask for more evidence from you or other parties.
I'd entirely agree with that. I think it's how we sometimes end up with DOLS Form 3 or 4, having the right answer, getting to the right conclusion about P's capacity, but we can't take it at face value and do end up having to go down the route of finding other evidence before the presumption is rebutted.
Excellent, thank you. The final question is directed to you, Dr. Rippon, which is this: that in terms of the information that's provided to you in the letter of instruction, is it necessary for you to see all all medical records and all previous assessments on capacity, or would you rather them being summarised?
Not in all cases. I think it's very much dependent on the case in question, and there's frequent occasions where I don't get to see all of the medical records. I need the medical records in order to be sure of that the first part of the test is met in relation to the diagnosis, and to sometimes it's necessary to get information about how the diagnosis impacts on that individual themselves. So it's not always necessary. If I feel that I haven't been sent enough information, I'll request that.
Excellent, thank you. Well, it falls upon me now to close this seminar. I'd like to take this opportunity again to thank Sir Nigel and Dr. Rippon for joining us today as our external panelists. It's been really insightful, and we really appreciate your attendance this afternoon. Thank you also to Aisling and Sophie for providing your presentation of an example case using the guidance of the ADMC case. Thank you all also for attending our seminar today. If you have any questions, any further questions you'd like us to look at, or any suggestions in terms of other seminars then please let us know on our usual email correspondence. But thank you very much for being here, and we'll see you all soon, hopefully in person.
Thank you, Sam.
Thank you, Sam.